Chapter 4. Stowell's judicial work and its results. When Scott became judge of the High Court of Admiralty, with its two distinct jurisdictions, he had attained a peculiar position for which he was especially fitted, at a time fortunate for his country and himself. As Lord Morley says of the appearance of Voltaire, in the phraseology of pre-scientific times, it might well have been called providential. His temperament was judicial. He was a masterly scholar and an erudite lawyer. He was a hard-working and shrewd, clear-headed and broad-minded. The union of these attainments and qualities, which may be summarized as a union of learning and sagacity, together with the inestimable gift of being able to apply his powers aright, produced a remarkable result. Judgments which are their fruit and representation. At the moment when Stowell became a judge, England was involved in a great European struggle and in a long maritime war. The sea swarmed with British cruisers, and with brave and energetic, not to say rapacious, privateers. The prize court was therefore in continuous request. Stowell instinctively realized his opportunity and set himself to fulfill a great task which was admirably achieved. How clear he recognized his position is to some extent evidenced by some words in a judgment delivered early in his judicial life. In 1799, in which also he definitely stated certain basic principles in regard to visit and search of neutral vessels by belligerent ships of war. I trust, he says, that it has not escaped my anxious recollection for one moment, what it is that the duty of my station calls from me, namely, to consider myself as stationed here, not to deliver occasional and shifting opinions to serve present purposes of particular national interest, but to administer with indifference that justice which the law of nations holds out, without distinction, to independent states, some happening to be neutral and some to be belligerent. Stowell pursued judicial ideals, and he perceived that he was placed in a position in which they could be realized and in which he could permanently create a body of British prize law. Many capable and honest judges would have been satisfied to deliver what Stowell called, in the judgments in the Maria, occasional and shifting opinions. There is, indeed, a great temptation to a judge of a prize court to look rather to present and transitory circumstances than to general principles. It has been said that Stowell leaned towards his own country, a belligerent nation. This criticism was certain to be made against his judgments, because in them he recognized the fundamental basis of maritime capture in time of hostilities, that it is in principle a necessary operation of war. For this reason he would not countenance any suggestion by which a blockade should be weakened. "What is the object of a blockade?" he asked. He answers the question by the words, "To cut off all communication of commerce with the blockaded place. I must, therefore," he continued, "consider the act of egress to be as culpable as the act of ingress. There are, and always will be, two schools in regard to the conflicting interests of belligerents and neutrals, one seeking to affirm the powers of belligerents, and the other to safeguard the convenience of neutrals in time of war. Stowell, whilst he recognized the supremacy of the belligerent, was equally careful of the cause of neutrals. Thus, he definitely decided that when a neutral ship carries a contraband cargo, the shipowner should not lose his freight and should only lose his freight and not his vessel, unless it was proved that the claimants had acted fraudulently. A sound basis of common sense underlies this rule, but for the moment that is not the point. The purpose of reference to the question in this place is to show Stowell's tenderness to neutrals, when it was possible to unite it with the safeguarding of the power of a belligerent. Again, he decided not that, as in the law of France, the purchase of a vessel from a belligerent by a neutral in time of war is absolutely invalid, but that it may be invalidated. Such purchases have been allowed to be legal, but they will always be open to much suspicion. At any rate, therefore, the neutral was not deprived of his ship without a judicial examination. In no respect, however, was Stowell more lenient to neutrals than when he very decisively ruled that under no circumstances could a neutral vessel be destroyed without payment of compensation. It is the primary duty of a captor to bring a neutral vessel and a cargo which is seized into port for the purpose of obtaining the judgment of the prize court as to whether it is or is not lawful prize. Stowell admitted no qualification or modification of the rule. It might be impossible by reason of the impracticability of placing a prize crew on board the captured vessel, or for some other maritime cause, to navigate a captured neutral vessel into port, but under such conditions the choice lay between release and destruction, with payment of compensation. Where it, the vessel or other property, is neutral, the act of destruction cannot be justified to the neutral owner by the gravest importance of such an act to the public service of the captor's own state. To the neutral, it can only be justified, under such circumstances, by a full restitution in value. Stowell thus safeguarded neutrals without embarrassing belligerents from a military point of view. This ruling was not only just, but was also for a belligerent diplomatically sound, since, speaking broadly, a neutral could not well complain if the act of destruction did not injure him financially. It is outside the scope of this book to discuss problems of international law and their bearing on future relations between belligerent and neutrals, but it certainly seems that Stowell's judicial decisions on the point should become of general application, though it must be admitted that the weakness of some neutrals will apparently lessen the value of such a rule unless there is sufficient union among neutral nations in time of war to safeguard a few general regulations at least. The continuous destruction of neutral vessels by Germany, and the refusal of the German prize court to order the repayment of compensation, have shown that only combined action by neutrals can have any practical value, and of this there has, in the present war, been a complete absence. The individuality of Stowell's work produces an almost indefinite but certainly existing tendency to regard him as an original creator, whereas, in fact, it was his admirable art to adapt the opinions of publicists and theorists to the facts which were brought before him. He seldom cited a writer on international law, but he had recognized treatises in mind, and he applied doctrines boldly and on his own responsibility, so as to produce a series of decisions on which his own individuality was stamped. The value of this body of law, at once clear, definite, and flexible, can be better appreciated by those who are not lawyers if it be compared with the present state of prize law in France, by which the Conseil de Prise is now guided, which is thus described by French writer. And I'm not going to try to read the French. From falling into this, Amas de Texte si varie, as the writer of this interesting paper, in another place terms French prize law, which can be studied in detail in Pistoy and Duverdy's Traité de Prise Maritime, Paris 1885, Lord Stowell for all time effectually guarded British prize law. In so doing, Stowell surrounded English prize law with an atmosphere of justice, not so much by actual phrases in the course of a judgment, as by the continuous exposition of the grounds of justice on which his decisions were founded. Sometimes, it is true, actual words are not to be found which heighten the effect of the general equity of the judgment by indicating a personal sympathy which, however, was not allowed to hinder justice. This is an unfortunate case, so we read in the two Susannas, "The court is very desirous that full justice should be done to the claimants, but the cargo is not equal to it. The question then is whether the captors have acted so irregularly as to make themselves liable. The answer was in favor of the captors, but the decision, while adverse to the claimants, recognized that they had reasonable ground for bringing their case before the court. In another and later case, Lord Stowell concluded a judgment by which a claimant was held to be a Dutch subject, whose vessel must therefore be condemned by observing that the court is therefore under the necessity of considering this gentleman as a merchant of the enemy's country, and of pronouncing the ship as the property liable to condemnation. It is not necessary to emphasize the suggestive art of this sentence, the implication of an imperious but proper claim of justice, not less than the courtesy to the claimant as an individual. Other and similar passages could be collected, but apart from their context they are less striking, and it is the cumulative effect of a whole series of judgments from which emanates, by reason of Stowell's masterly manner, a sense of even-handed justice. A very different scene was thus spread before the legal observer after the lapse of a little more than a quarter of a century from the day when Sir William Scott took his seat as a judge. 9 volumes, except the 2 last entirely filled with prize cases, enshrined the decisions of Lord Stowell in the prize court, and in them were contained a series of precedents so comprehensive, so full of principle, and so logical that the collection was of greater value than any code, since it exhibited, as no code could, the application of judicial principles to concrete and varying facts. From beginning to end, they retained a continually high level of thought, learning, form, and expression, revealing keen perception of legal principles with rare insight into the value of facts. The long continuance of the war against Napoleon was a fortunate circumstance for Stowell in the role of lawgiver. It made his judicial position unique. For a very long period, year after year, he alone was the judge of the prize court. No colleague modified his views or differed from his conclusions. No colleague's judgments varied the continuity of his judicial style. He was master of the procedure of his court, which became a kind of individual judicial domain. The prize court was thus, through a concurrence of circumstances, identified with a personality. There was, it is true, a court of appeal in the shape of the Lords Commissioners of Appeal in prize cases, on which body some able men were to be found. Sir William Grant, 1772 to 1859, for some time Master of the Rolls, was one of these, and seems to have usually acted as President of the court. His reputation among his contemporaries, at first as a parliamentary debater, and later for his judicial grasp and the admirable expression of his judgments, was very high. But the decisions of this tribunal were, as a rule, quite baldly stated, and, except those delivered from 1809 to 1811, were not republished in a volume. And even in Acton's reports there is scarcely a judgment which is more than a few lines in length. Stowell's decisions were, moreover, affirmed with an agreeable monotony which assisted in adding to the authority of his judgments. The long-drawn-out war further enabled him to accumulate his judgments and to link them one to another, to develop an embryonic principle and to establish it by reference not to one set but to a series of facts. A sense of continuity and of a system was thus created which gave the reports collected by Dr. Christopher Robinson and Dr. Dodson the value of a treatise with the additional and important weight of judicial authority. During the long period of peace which existed from November 20th, 1815 to March 27th, 1854, this special body of jurisprudence became more and more recognized as authoritative and national. A lasting result of Stowell's action was to introduce a remarkable certainty into English prize law. Judicial precedent being, as it is, the basis of modern English law, Lord Stowell's precedents, especially uninfluenced as they were by previous decisions, formed at once a fixed juridical groundwork, and as they were so little varied by the Court of Appeal and attained at once among lawyers and statesmen a high repute, they became year by year more solidly established. Lord Stowell was thus, in the words of an eminent English judge of the present day, rather a law-giver than a judge. But for Stowell, there would never have been that sharp difference between the clear and definite body of English prize law and the unsystematic and indefinite collection of administrative decrees, decisions, and academic opinions which constitute continental prize law. Nor would the prize law of the United States have grown up, as it has done, in the same form and on the same principles as that which was evolved in Doctors' Commons between 1798 and 1828. Lord Stowell, in fact, lifted British prize law to a quite different plane from that on which it had previously rested. It emerged under his guidance from the condition in which all other prize laws still are, to one which placed almost the entire groundwork on a basis of reasoned principles. The effect he could have little foreseen, for now his judgments are not only in some degree the law of the United States, but of all British dominions which have come to manhood since his time, and in which prize courts have in recent times been established. During the present war, his decisions have guided the judges of British prize courts from Egypt to Canada, from the Cape of Good Hope to Hong Kong.